Okay, so we have the appeal of the Gliding Shops LLC Real Estate, State Street and Thames Street. This is a decision on remand repose of the Historic District Commission dated January 25th, 2019, in response to the Zoning Board of Appeals decision dated October 29th, 2018, and for further discussion on the appeal of Bristol Historic District Commission approval of the construction of a mixed-use building with 20 residential dwelling units and a restaurant use, submitted by James W. Radia of SAT Development Partners. Okay, guys, we're going to give each party 5 minutes to just make a discussion and complete the rest of their case, because we have all the information in front of us. We've had it for a while, so we don't need to rehash it all. You guys just get 5 minutes, and then we will make a decision, okay?
Mr. McGillivray will go first.
And I wanted to clarify one thing, that this board made a decision to remand. It did not make a decision to reverse. Our decision was to remand the HDC. That's our decision. It was not a reversal, it was a remand. That's a clarification if anybody was confused on this. Go ahead, sir.
Thank you very much, and thank you for giving us the time and reviewing all the briefs. I'm going to try to stay within 5 minutes. If you give me a little bit of leeway, I promise I'll try to keep it very short. So as Mr. Chairman just noted, the decision was remanded to the HDC, quote, for more specific findings of fact and discussion with regard to the weight that the Commission is attaching to various evidence based on the record as it currently exists. So this was a closed universe. We weren't supposed to go outside the record. And the remand document that the HDC issued says that it comes down to CalFELS. It says specifically, the focus of the zoning board's remand decision comes down to the question of why 4 of the 7 voting HDC members found architect CalFELS, who testified regarding architectural and historic preservation significance, and whose resume was entered into the record testimony, more credible than some of the witnesses, both proffered by objectors and members of the public who had architectural history qualifications. So it came down to, why did they believe CalFELS and not the 10 witnesses who were experts, who had actual architectural history backgrounds. And what the remand response from the HDC says, on December 27th, several members of the HDC noted that CalFELS had appeared before them previously, and that the designs he had presented previously on other applications have always been in keeping with the HDC guidelines. Now that's improper under your remand. Those designs were not part of the record. CalFELS didn't present them. The applicant didn't offer them as evidence. They weren't subject to cross-examination. During the public meeting, we couldn't look at them and decide whether they actually were in conformance with the HDC. So right away, you have evidence outside of the record that they're relying on to prop up the architect CalFELS. They also said that he seemed credible in other testimony. Again, this other testimony is not part of the record. It wasn't available by way of transcript. It is something that was conjured out of the minds of the HDC members, and we did not have access to it. It was not entered into evidence. In particular, Chairman Lima said, the architect for this project has appeared before the HDC several times through the years. Based on my personal observation, he has been credible. The designs that he has presented have been in keeping with the HDC guidelines, and he has been accurate in the history of the project and sensitive to the architecture of the district. So she's relying upon previous testimony that's not part of the record and her own recollections to support CalFELS. And based upon that extra and outside the record evidence, she's choosing that over the 10 witnesses that were presented that said that this was not in keeping and that it violated the guidelines and the Secretary's of State's Secretary of the Interior standards. They also said that that members relied on the memory of the previous 2007 approval. This again was not on the record. They also, on the same page, page 4, they relied on some of their experience at the Technical Review Committee in staff meetings, which were prior to the, quote, formal submission. These are clearly not on the record. So you tell them to go look at the record and tell us what you're paying attention to and what you're not, what evidence you're looking at, what you're taking to be important. They come back with things that they have memory of that are not evidence on the record. Now this is even more true with respect to the guideline rule 3. I'm really cutting my argument short here, but my second point is an example of this is the HDC guideline general criteria 3. And as you are well aware, that talks about new construction west of Hope Street. And general criteria 3 says, with the exceptions of the mill complexes on the north and south ends of the Thames Street, so those shouldn't be considered, the area is characterized by small buildings on conventional size lots. So now you know what it looks like. That's the character. The small scale should be respected, and new projects should not require the combining of existing lots. The combining of existing lots. So what you have with this one is another example. They don't give you evidence showing that this fits the character in the small scale. Instead, they give you recollection of the history of larger buildings that may or may not be appropriately considered, which their recollections are not part of the record. What you have basically is not, they don't come back and point to, here's the evidence we looked at that shows that this fits the scale, the small scale, and meets guideline number 3. They show you why the small scale should be ignored. It's just the opposite. And the guidelines can't be ignored. They struggle mightily to say why these are just guidelines, that you don't really have to pay attention to them, we don't have to obey by the small, that's old news. And as I said before, section 14.4 of the Bristol Town Ordinance makes it clear that those guidelines have the same power as any other part of the ordinance. So I'm going to rely on my brief, which, as you may have seen, has tables that set forth the evidence on each side of each of the issues. And the overwhelming evidence is clearly in favor of rejecting a certificate of appropriateness. Instead of doing what this board told them to do, they went back and they got evidence outside of the record. They relied on things outside of the record. And this, I think, is just an example and an admission that the record does not support the finding of a certificate of appropriateness, the existing record. And so I'm going to ask, based upon the overwhelming evidence that's been presented, witnesses with over 250 years of architectural history experience compared to Mr. Kalfels, we're going to ask that you reverse the HDC and find that a certificate of appropriateness should not issue. If you do otherwise, you're basically saying it doesn't matter how many witnesses you bring in. If you have Kalfels on your side, this is the guy we trust, based upon previous experience, based upon staff meetings, based upon technical review committee. It's not appropriate. And it's not what this board asked the HDC to do. Thank you.
Thank you. Good evening. For the record, Andrew Teitz, T-E-I-T-Z, representing the Historic District Commission. And I also will rely on our brief as well as the remand response from the Historic District Commission. I think they both speak for themselves. I'll just address a couple of issues raised by Mr. McGilvery. He talks about the recollections of the members of the HDC not part of the record. And I object. First of all, I have to say, metaphorically, what is history if not what we recall of the past? And the job of the Historic District Commission is to determine if the new things that we do, whether they be rehabilitating old buildings or building new structures, as in this case, are they appropriate for the historic district? So I think it certainly has to include the history of the district and the history of the buildings. But more to the point, the recollections of these members are the personal knowledge. And I'm not going to go through all the cases that are in the brief, but I think you know too. Just as you are entitled to rely on your personal knowledge, we are not in Aroostook County in Maine, where it takes an hour plane flight to go from one end of the county to the other. We're in Bristol. Everybody has been here. This building is a block away from Town Hall. Yes, there were formal site visits in the past, including actual visits inside of the previous building on this site, as testified to by the Historic District Commission members, as they discussed. But even beyond that, they're being there many times. This is not something where you need to have a formal site visit. People can rely on it. The important thing that the law says is that people put on the record what is the basis for their recollections. And that you have there. People who've lived in the area, owned property for almost a century there, have been on the board for 20 and 30 years, and know the area. That's the personal knowledge to which they can rely on. It's also part of the personal knowledge that they can rely on as they judge the credibility in front of them. And this is a difficult question. As I said before, this is a close decision. The Historic District Commission decision was 4-3. The Planning Board decision was 3-2. This is something about which reasonable people can disagree, and they did disagree. And I think this is the case, though, where the law provides that the Historic District Commission should be judging the credibility of the witnesses in front of them. There was more than a scintilla of evidence before them in support of the decision. And they've given you the reasons for that, both their personal experiences with this architect. And Mr. McGilvery has said that that wasn't in the record. We've added stuff to the record because anything he testified to in the past or his plans in the past aren't part of the record. But they weren't relying on the subject matter of his testimony or plans in the past. It's not that he came in 2010 and said, you know, the Belvedere should look like this. No, they were basing it on their general experience with him, that he had appeared before them in previous projects, had been knowledgeable, and the projects turned out the way he said they would turn out. And based upon that overall experience, which is the same thing as their experience with the district, that was part of the factor leading to them to provide him with the credibility. Whereas several of the other witnesses on the other side were mainly conjecture, worried what might happen and not. But in fact, as what really is being said by Mr. McGilvery too is about the question about this, the criteria. And I just want to address that, the criteria, the guidelines of the Historic District, and specifically this criteria too. I first of all want to emphasize, as put forth in our brief, we don't believe the guidelines are incorporated by reference in the ordinance. We believe the rules of procedure are, and they specifically direct, as far as for actual decision, the Secretary of the Interior standards. So that we don't believe that they have the force of ordinance. But even if they do, it is not the same sort of ordinance that you as a zoning board have, where you have to make several findings. It's got to be least relief necessary. It's got to be more than a mere inconvenience. It's got to be a unique shape or character of the lot. And if you don't find all of those, you can't grant the relief. These are different. These are subjective guidelines. And if you read them, there's no way that any project could meet all 14 of them no matter what. It's a series of guidelines, and we coded specifically one of the ones that within itself has 3 internal conjectures. We don't want this, but this is okay, and so's this. So they're guidelines, and what they were required to do was look at it and evaluate it and make their decision based on the spirit of it. And I think that's what we've come down to, and as was noted in the decision itself, it's this relationship between horizontal and vertical thrust of the structure, that's the shape, and the context of the historic buildings in the immediate vicinity. And those are the questions. The shape, what's the shape, and what's the immediate vicinity? And I think when you look at it, you'll see, again, there's far more than a scintilla of evidence about this information, and they applied it. They may not have applied it as everybody wanted. They couldn't have applied it as everybody wanted because people were split 50-50 on it anyway. They took their years of experience and knowledge, they took all the proceedings before them, and I do just want to correct, the 2007 plans were in fact part of the record. They were submitted very soon at the beginning of the process. They were part of the file and they were part of the record, the previous appeal. It's not legally binding because it expired, but they were part of the record. So the HDC members took all of that, looked at what was in front of it, based on their own experience and knowledge. They judged the credibility and they found the decision, they found this to be appropriate to the historic district. And I would respectfully ask you to uphold that decision.
Thank you.
I'm available for questions if you want.
Good evening, members of the board. Michael Resnick on behalf of the applicant. I too will rely on my brief in major part, as well as the town's. And I'll just quickly address a couple issues and again be brief. It was completely appropriate for the HDC members to rely on their personal knowledge and experience in voting in favor of the project, and to disclose their reliance on that personal knowledge and experience at the hearing and to fashion supplemental findings of fact based on that knowledge and experience. The cases in Rhode Island are absolutely legion on this issue. The Superior Court, as an example, has broad powers to remand. And there are many cases where a remand has been made because a Superior Court determined that sufficient facts were not found on particular issues. And what they do is they remand to a board to disclose or to supplement those findings. And in many cases, the boards have relied on personal knowledge, as is their right, and as long as it's disclosed on the record, this has always been viewed as legally sufficient. And so to argue that this is somehow an expansion of the record is just not found in the case law. In fact, this has been done many, many times. I'll just cite you one case as an example, and that is Marvelli v. Zoning Board of Review of City of Pawtucket, case number 87-4607, Rhode Island Superior Court, February 3rd, 1998, acknowledging that municipal boards and commissions may consider factors which are within their personal knowledge, even through observation, experience, or inspection. And so the concept that it was not legally appropriate to put these issues in play and on the record is just not founded in the law. What I hear a lot from Mr. McGilvery this evening and the objectors is this concept of quantity over quality. And the comment that we have 10 experts with 250 years of experience, and that should somehow in and of itself outweigh Mr. Calfell's, Mr. Adaman, and Mr. Pimentel's testimony. That's not the role of this board. It's the finder of fact that determines credibility and weight to assign to expert testimony, and the finder of fact here is the HDC. So the HDC served as the finder of fact. It was up to the HDC to determine what weight it assigned to both experts. And what Mr. McGilvery is really requesting that this board do is to supplant their own opinion with a board, to somehow weigh the evidence, and to come to the conclusion that one gentleman of sufficient background, expertise, is not sufficient to support the approval of an application, even in the face of a multitude, a myriad of experts. And that's just not the case. We're not here to reweigh the issues. And again, Mr. Calfell's and Mr. Adamant's credentials speak for themselves. The resumes were part of the record. I would invite you to look at them. Mr. Pimentel has served as a zoning enforcement officer, as a planning board member throughout various municipalities in the state of Rhode Island. He's well known, his experience is well known, his credibility is the same. And so, you know, I would ask you to consider that when determining whether or not someone is qualified to give expert testimony, the analysis is whether or not the proponent party, here the applicant, showed that the witness qualifies as an expert in the applicable subject matter by his or her knowledge, skill, experience, training, or education. So not to belabor the point, but I invite you to take a look at Mr. Pimentel's report, his neighborhood analysis. And in fact, many of the comments that were made by the HDC members, their personal experience and their personal knowledge of the area are really commiserate or parallel to that neighborhood analysis. And in that report, you'll find much of the same determinations in that report. And you know, I'll just share with you a couple snippets of testimony that was provided by Mr. Calfell in the original presentation to the board. And he said to the board that the mission of Union Studio is to, and I quote, to devote our skills as planners and architects to the creation and repair of neighbors and communities of all types. And for us, this includes renovating our historic structures with care is crucial in maintaining our architectural heritage for certain. But it also means that the design of new public places, neighbors, and structures, they need to resonate with the community they serve and certainly work to enhance our civic life. And for us, this was very much in our minds. It's the lens through which we review every project we work on. It was very much in our minds as we began working several months ago on this important project in Bristol. And so what I would suggest to you is that the HDC members, in their experience, understood that Mr. Calfell's not only had the education and experience, but he also was looking at the important issues of maintaining historic integrity, but designing for a new world. Designing in an area where flooding are issues, real world, other issues that come into play, and not viewing these in a vacuum. And you know, just for a couple other examples, Union Studios has been given the award for Providence Preservation Society. This is all in the resume. They've been a recipient of a National Housing and Rehab Association award. And Mr. Calfell has authored articles, The Classical and Vernacular Traditional New England Architecture. So I could go on and on. These are individuals that have great experience, and it's not your task to reweigh here today. It's your task to affirm the findings of fact made by the board, which was based on their opinion that these are credible individuals. Thank you.
Thank you. Okay, so we're going to have a discussion now.
Well, we're still dealing with the same standard of review that we discussed at the initial meetings on this appeal from the Historic District, where we are not, where we...
If I may, Mr. Vice Chair.
Sorry, what?
Since this is a separate proceeding and may result in a separate appeal, just to keep the record tight, since there may be two separate proceedings up there, although they might get consolidated, I was willing to read to you exactly what the statute says about the standard of review, unless you've got it there and you'll read it.
I have it right in front of me.
Excellent, thank you.
Thank you, Mr. Henry. So the standard of review on this appeal from the decision of the Historic District Commission states that we are not to substitute our own judgment for that of the Commission. And we are not to reverse the Commission decision except upon finding of prejudicial procedural error, clear error, or lack of support by weight of the evidence in the record. When we initially considered this matter, members of the zoning board sitting as the Board of Appeals were unable to determine whether there was sufficient weight of the evidence in the record to support the affirmative decision by the Historic District Commission in favor of issuing a certificate of appropriateness to the development. And that's why we remanded it, so that they would make more specific findings and that they would also discuss so that we could judge whether the evidence was sufficient. So we wanted them to discuss the credibility of the evidence and the witnesses who testified both for and against. So that was what we sent back to them on remand. There was a written decision on the appeal that remanded it back to the Historic District Commission. And the remand response is what we got from them in January. And so now it's our opportunity to decide whether any of the grounds that would require us or allow us to reverse are present, and whether or not there is sufficient weight of the evidence to support the decision. So that's what we have to talk about now. I haven't heard the parties recently arguing that there's prejudicial procedural error. Perhaps that was what Mr. McGillivray was doing now tonight when he said, and in his brief when he said the proceedings on remand, in his view, opened the matter up beyond the record as it existed when it was presented to us initially. Maybe that's an argument for prejudicial procedural error. But most of the thrust of the arguments in support of and against the decision have to do with whether there is sufficient weight of the evidence in the record to support the 4-3 decision by the Historic District Commission to grant the certificate of appropriateness. So we could talk about whether, could break them into two separate discussions, whether what happened on remand amounted to expansion of the record or not, and whether that, if it did, is that prejudicial procedural error, and then talk about the sufficiency of the evidence. And I don't think that they expanded the record. I think they discussed the record. We asked them to consider, we directed them to consider the credibility of the evidence and the credibility of the witnesses. They discussed their knowledge of Mr. Calfels. They had their personal knowledge, helped them make a determination whether we agree with it or not, that he was a credible witness. So I don't see that as an expansion of the record, to have that discussion of their experience with Mr. Calfels in prior matters.
I feel the same way, because this board actually does the same thing. We use other situations that we rely on, say people are experts and they've testified in front of this board before. So that happens quite frequently, so I don't think it is an expansion of the record at all. So.
And even if it were, was that by itself enough to say that it's prejudicial procedural error? I don't think it was a procedural error. And I think we asked them to adjudge credibility. They did that. Or at least that's what they were trying to do. So I don't think it's procedural error, and I don't think it's prejudicial. So I think the real question then, I don't want to move beyond that if other people want to say something about whether they see anything that could amount to prejudicial procedural error.
I don't know that I see any present prejudicial error, but this is, sometimes we're getting down into the real details when we listen to the appeal and the discussion, when we listen to the discussion. This isn't really right now about all the things the HDC is very, very good at and very talented. This is about the size and the scale of the project, and I think that's the thrust of the appeal. And I would have liked to have seen a little more about the people that presented other, but you would expect that the people that were there to present alternatives, it would be conceptual. No, it's not conjecture, it's okay, here's another way to do the development. So you wouldn't come in with drawings and plans in order to express that opinion. So it's going to be conceptual as an alternative to one building, one connected building.
David?
I go along with what the board, I go along with what the Historical Commission came up with, the facts. I mean, they're pretty knowledgeable, they had guidelines to follow, and for the size of the building, I don't think it's really that big compared to what's down there now. So it just blends right in with the rest of the area.
Tony, how do you feel about this?
I'm in agreement with Bruce where I don't see the prejudicial procedural error or clear error. And ultimately the question was the evidence properly weighted? And I do believe that on the remand, on the remand that it was addressed. And to that point, the size and the scale of the project is really what's in question. Whether it did meet the Historical Commission's view, and whether the Historical Commission felt that the building was appropriate. So, with that being said, I'm not 100% certain on the weight of the evidence in the record. But at this point, I do feel that it was addressed in the remand.
Yeah, I mean, it's not up to us to weigh the evidence. That's their job. And in terms of the size and massing of the project, at some point, it will be up to this board, sitting as the Board of Review, not the Board of Appeals, to make judgments about the variances which would be required to build it to the size and mass that they're proposing. And they may or may not get that relief from this board at that time. That's going to depend upon what's presented in a petition for variances. And I'm not, I don't think it's our job to decide what their job is. It's not our job to decide from a Historic District Commission the appropriateness of the project. It's our job to decide, was there procedural error, clear error, or does the decision, is the decision not supported by the weight of the evidence? And as Mr. Tights has told us many times, as long as there's a mere scintilla of evidence, that we can identify that's more than a mere scintilla of evidence that supports the decision, then that's sufficient weight. We might not have reached the same conclusion, but that's not our job. Our job is just this on appeal, these limited grounds for review. So, I'm not far off of Charlie that it would have been nice had they kind of gone through in a little more detail the various evidence presented by by the witnesses both for and against, but they identified what they thought was credible and why, and they identified what they didn't attach as much weight to and why, in their judgment, they didn't. And I think that's what we asked them to do.
I would agree. I said it was a discussion point that I would have liked to have seen. I would have been more comfortable if we had more information on the other position. But okay.
So they followed the procedural steps. They did follow the, we might not agree with all the information, but they did follow what they were supposed to do.
I'm not saying I disagree or agree, I'm just saying that I would like to have seen more narrative or more evidence about the reason that we don't think these positions, that we think they're secondary to the one that they determined is the right one. I would have liked to see more, I would have felt more comfortable, but I don't see any reason to reverse based on that.
And we will have our time with these people. I got some time to zoning board itself.
So that's on the expert opinions. Right. We're going to talk about the standards a little later, I guess.
I'm sorry, what?
The standards.
Okay, what about the standards?
Well, there's general criteria, and I'm not going to go through all of them, but public views of the waterfront from both public property and existing private structures must be considered in all new construction. The design of buildings for this area will be judged from all elevations, including those visible from the water. I'm sorry. Would you like me to start over? The design of buildings for this area will be judged from all elevations, including those visible from the water. With the exceptions of the mill complexes on the north and south ends of Thames Street, the area was characterized by small buildings on conventional sized lots. The small scale should be respected, and new projects should not require the combining of existing lots. So when we got the initial decision that we reviewed, they talked about the Duval Hotel that was destroyed in 1938, I believe, and so there was no mention of that. But they took the two exceptions, which is Robin Rug and Stone Harbor, and they used that to support the decision. And I guess I'm a little confused on what these guidelines mean, because I see the two larger building complexes used to make a decision on the new project, and I think they're saying that those are exceptions. So I didn't see that in the discussion or the evidence on that. So in other words, they used those buildings to justify it.
Well, they did, but they also used quite a few buildings that are in the designated area.
So that word.
What?
He mentioned the Royal Hotel.
That was, yeah, it was right, that empty lot on State Street. That was the hotel.
You're speaking today. Okay, yeah, that's good. That was one.
So, just, you know, they do, in their discussion on page 8, on the remand response, do identify a series of buildings that are in the immediate area, which they are saying that area is characterized by small buildings on conventional sized lots, and they identify a number of buildings that are in this area. Judge Roy Bean, Thames Street Landing, the Belvedere, Maritime Center, Fire Station. There's buildings on Thames and on State. So I mean, they're trying to figure out appropriateness of this structure using these guidelines. You know, I don't agree with Mr. Tice that they are meaningless, or maybe he didn't say they're meaningless, but they have some force and effect. But the commission in its remand addresses that general criteria, number 3, and identifies buildings in the immediate vicinity that they think this project, as proposed by the developer, will fit in and will respect that size and scale. I might, and you might not agree with that.
I agree. It's not a decision. That's not our decision.
Right. I might not agree with them. Just that, you know, comparing this structure in its size and massing, you know, but that's, you know, that's what they did, and they reached a conclusion that it's not inappropriate. You know, even taking that guideline into effect. So, I mean, I think what we hadn't seen from them before was, you know, a discussion of specific reasons why they felt the criteria were satisfied. And they're giving us reasons. I might not have reached the same conclusion, but they're giving us reasons they did what we asked them to do. I think it's very hard, given the remand response, to say that their decision, the decision of the majority of the Historic District Commission, lacks support by the weight of evidence in the record. They identified things in the record that they thought supported meeting those criteria.
And I'm not going to disagree.
No, it's definitely in here. Like I said, we don't have to agree with what they say, but it's there.
Right, I agree. I've said I'm not going to disagree, but it's...
Yeah, it's in there. It's definitely in there. Yes. Okay. Guys satisfied with this discussion? Everyone? Yep.
Well, we were asked to decide initially whether we affirmed or reversed the decision, because that's the appellant had appealed that decision to us, and we didn't make that decision, we remanded. So we have to decide now whether we're going to affirm or reject, reverse that decision. So I'll make a motion that we affirm the decision of the Historic District Commission granting the certificate of appropriateness for the property at State Street and Thames Street as proposed for the construction of a mixed-use building with 20 residential dwelling units and restaurant use, because the record does not disclose prejudicial procedural error, clear error, or a lack of support by the weight of the evidence in the record. The remand response addressed the credibility that the Commission attached to the various aspects of evidence. There's quite a lot of evidence. They weren't required to go through each and every piece of evidence in order for them to find more than a mere scintilla of evidence that would support their decision. And they reviewed the criteria that we asked them to review, identified why they attached weight to different expert testimony that was presented, and how in their judgment the issues, the technical issues of vertical and horizontal thrust and massing and size and scale, they were satisfied from the record. And there appears to be more than a mere scintilla of evidence supporting that. So for that reason, I move that we affirm the decision of the Historic District Commission.
I'll second.
All in favor?
Aye.
Opposed? Okay. I think that's it. Thank you. Thank you everyone for coming.
I'll make a motion to adjourn.
All in favor? Aye. Opposed? Okay, we're adjourned.